Parsons here, paralegal, and today I'd like to talk about what happens and what you should bring to your initial interview with your paralegal and what correspondence you should have with him or her prior to that initial meeting. A little bit fact specific in terms of what type of meeting that you're setting up. The things that you will require for a provincial offense or traffic matter are a little bit different than what you would require for a small claims or landlord-tenant matter. The initial thing being, of course, a conflict check. Conflict checks are typically not required for provincial offenses, Highway Traffic Act matter. It's just yourself and the Crown that's involved. So typically, a conflict check is not required. However, when we're dealing with small claims and landlord-tenant matters, um, human rights complaints and that sort of thing, then you'll want to do a conflict check. That conflict check should happen immediately when you're talking to the paralegal or the paralegal's office, even before you begin to disclose any information, and preferably before you book an appointment. The last thing you want to do is book an appointment, show up, find out that your paralegal can't talk to you because they represent the other side. Or they have represented the other side and you've wasted your time. That's the kind of the best case scenario in a conflict situation. And the worst case scenario is, of course, they are actively acting against you and have to disclose that information. You have to go elsewhere, but you're never going to feel comfortable about that. So, first things first, when you're calling up a paralegal office, identify the type of matter it is. Say, I'd like to book an appointment for my whatever this is. I have been charged with something. I have been served with papers relating to. I have an issue with my tenant. I have an issue with whatever. And I need to come in and speak to somebody, or I need to speak to somebody over the phone, over the internet. When that appointment is booked, you then want to say, okay, now before we get too far down the road, can you assure me there's no conflict? That should automatically happen at the paralegal's end. Shouldn't be something you're concerned with. But of course, it's your time as well as the paralegal's time. So you're going to want to make sure that that happens and that a proper conflict check is conducted so that when you go down there, there's no surprises. To do that, you don't want to feed the name of just one party. If you have 3 tenants, you got to feed the name of all 3 tenants to the paralegal or the paralegal's assistant so that those things can be checked. If it's a small claims matter, same thing. You want to run through the name of the business, if it's a business, and the principles of the business. So somebody might be operating a business, and the principal of that business as well, you want to run that name through the system just to make sure that there's no confusion. Somebody might not recognize a business name, but might have done work for that person in the past. So, things are all good. You've gotten that far in terms of conflicts. There's no conflicts. You can speak to this individual who you may or may not choose to represent you and who can give you advice. What do you bring? Well, you want to show up on time, obviously, and you want to bring with you all your documentation. Sounds simple, might not be, but all you can do is try. One of the things that you want to bring with you is identification. Law Society requires that each and every file we open, you provide identification to your service provider, be it a lawyer or a paralegal. So they're going to ask you for identification, and you're going to have to provide, say, that's a requirement under the Law Society. It's not something that is governed by your individual paralegal or lawyer. Part and parcel of what goes on, it's part of the routine. You can say, I would prefer you not keep that information. The lawyer or paralegal can then deal with that as they will, but you are going to have to show that identification so they may satisfy themselves. In terms of if it's a provincial offenses or a traffic matter, you're going to want to bring a few things that might not immediately be evident. Obviously, whatever you're charged with, the charging document, that you're going to remember. Driver's license, you're going to remember. But you might not think to bring in your insurance, your slip for when your insurance renews, and any previous charges. So you might want to pull an abstract of your driving history for the last 3 years if there are any other charges that you've had in that 3-year period. One of the things that a traffic paralegal should be looking at is what potential impact this could have on your insurance rates when your insurance renews, that sort of thing. They don't directly relate, but it is part of what affects you. And a good paralegal should be looking at putting you in the best possible position you can be in. In terms of landlord and tenant matters, you want to bring in all documents you've had with the tenant, starting with the application, any application that you've received, any information they've given you, credit check you had done, application they provided, and then the lease agreement if there is any, and all your communications with the tenant. So bring that in, and your paralegal will want to take a look at that at some point in time. The small claims matters, pretty much the same documentation as the landlord and tenant, just as it relates to the matter at hand. For instance, if it's a home renovation matter, the quotes and emails relating to the transaction, texts, if you can pull those up, that led to the formation of the contract, any conversations. If there were witnesses to the action, you may want to find out last names and phone numbers, contact information. Bear in mind that this is preliminary, so jot it down if you have it, but don't go crazy about it. For small claims and landlord-tenant matters, it's nice if you have a few moments and you're setting up for the interview, do a timeline for yourself. It will help you and your representative understand what happened in the order it happened. So a timeline is very useful. Remember that you're paying for somebody's time, and the quicker you can impart the most information, the quicker you can get your advice and the quicker you can get your assistance. You don't want to be spending a ton of money you don't have to, trying to have both sides understand exactly what happened. So keep it succinct, clear, and as much as you can, follow that timeline type thinking when you're talking to your paralegal or your lawyer. They will ask you questions. Follow that train of thought. There's a tendency to tell a story. A lot of what you're thinking about may come to bear later on, but follow their interview process. Allow them to pick out the bare bones, the essential legal elements that they're looking for, and then they'll fill in what else you may know that's relevant or not. But keep in mind, again, you're paying for a provider's time. This is your money. When they're keeping the discussion focused, it's to save your money and their time. And once the initial thing has been done, most providers will say, okay, now I can give you an opinion. Is there anything else that we haven't discussed? Or in the course of that opinion, there may be some discussion about different things that didn't come up in the original. But remember, always, number one thing, when you're hiring somebody to represent you, you have to have a comfort level with that person. You have to feel comfortable that you're respected, that you respect them, that there's an initial feeling of trust, and that you feel comfortable in the way that both parties relate to each other. That is going to be the person that's going to put your best foot forward, that's going to represent you and essentially acting on your behalf for something that's really important. You want to make sure that they have the same goals in mind. They understand what your end goal is. Because the end goal is never to go through a legal process. Whatever you're doing, you have an end result that should be clearly identified at the end of the interview. You say, we want this. And that should be identified, and that should be the goal. And both parties should be on the page, the same page, to make sure that that is what you're attempting to do. Bruce Parsons, have a great